gather in. You see the topic. Memorandum of Trust and how to file a memorandum of trust. Are y'all ready to file your memorandums of trust, my people? Gather in the class right now. Gather in 407-300-5377. This is the United States Private Enterprise Free State with another public announcement. So, Memorandum of Trust. Well, let's get into it, my people. Memorandum of Trust. And how do we file a memorandum of trust? How do we file a memorandum of trust? Does anybody out there know how they file a memorandum of trust and get it on the record? Now, we're going to give you a lot of info right now on how to file a memorandum of trust. It could be a revocable trust. It could be an irrevocable trust. It could be any type of trust that you choose to file. Some people are like, yo, I can't get my trust. I went into the county court. They denied me. I did this. I did that. Well, check this out, my people. Only if the document relates to real property is how you can file. Not all the way right. So, we're going to go through a little class right here. You know, now, a trust can be filed on the acreage system. Now, you can record a trust if it appears in documents like deed transferring property into the trust, assignment of mortgage to the trust, certificate of trust attached to a deed, trust agreement referenced in a property conveyance. So, for example, John Doe is giving something to John Doe Living Estate Express Trust. This makes the trust appear in the public land record. Okay? Now, how are we going to record the trust on the acreage system, my people? You're going to go to the acreage system. You're going to do it as an e-recording, my people. Now, if you have a house, that's great. Prepare it as a recordable document, such as a deed of trust, because the acreage system is only going to take a deed of trust. And if it's a certificate of trust, you have to reference the property, my people. And you have to have an assignment to the trust. Now, the elements, my people, you have to have all your documents notarized down at the county clerk. You have to have your block and your lot number. You have to. And you have to have a cover page. To get in the acreage system, you have to have a cover page. It depends on what type of document you're filing. It's going to reference the number of the cover page of the deed, because the acreage system is going to take deed of transfer of toward the tax forms. It's applicable. Okay? Now, you're going to upload through the acreage system, through the e-recording of the acreage system, my people. It's an e-recording submission. So you may not have to walk into your county clerk's office at all and get rejected. So you have the title company. Some attorneys can go and get shit done quick, but why would you give your trust to an attorney? Because you're giving him now The attorney owns everything that's yours. So you may pay a recording fee through that acreage system to upload your documents or your deeds with the documents. Now, basically, my people, the acres will not accept it if it's not a transference of property, such as, and we're going to get into it. Okay. Now, instead, you may want to record it at the county clerk as a miscellaneous record if they accept it. Now, you can go down to your county clerk in your county, in your state, wherever you live. Okay? So, these records can be recorded at the county clerk as in the miscellaneous records department, a certificate of trust, a declaration of trust. Okay? All documents must be notarized and authenticated. Now, you may have a trustee, and if you are the trustee, then most trustees record only a certificate of trust instead of the entire trust agreement. This protects the privacy, but proves the trust exists, my people, because you want your trust to exist. Now, certificates include the trust name, the trustee, the date of the trust was created, authority of the trustee, and a notary. So it's very important that if your situation, if you have a living trust, a living estate express trust, you would normally record a certificate of trust, declaration of trust, or a deed transferring property into the trust. So that's how you can get it done on the acre system, but you can walk it down into your county clerk. But you have to know how to present your trust package. Okay? So basically, if you have a revocable living trust certificate of trust, you can put that on the public record. You're not actually filling it out in the court. You're recording it with the county clerk's land records, okay? In the miscellaneous records division or at the land record. So you would have to see if they have a land records department. It's going to be more money to record it in a land record department as opposed to a miscellaneous department. Some places it's $350 to record it on the land record that a trust exists. But you have to be transferring property. And we're going to get into what property really is when you're transferring it into a trust. Property is not what you may think it is. So, my people, you can record your certificate of trust with your county clerk. Okay? Now, you can also record it wherever you live in your state. So, it can be done under your miscellaneous records or your land records, non-property related documents. Okay? So, do not file the full trust, only a certificate of trust. No one is supposed to see your entire trust. Now, your certificate of trust is going to include your trust name, the date your trust was created, your trust name, you as a fiduciary, you as a trustee. You need a statement that the trust is either revocable or irrevocable. You need the powers of the trustee, the mailing address, the signature of the trustee, and you need it to all be notarized by the county clerk. Now, your document, the type your certificate of trust, you know, you're going to sign in front of the notary. And then you're going to go to either to the land records or the miscellaneous records. You must have all your fees available, blank check. Some places take cash, some places don't take cash. So you're going to have your cover page because it's recommended, and you're going to include your certificate of trust. It's going to be a cover page, your certificate of trust, your name as the submitter, and your return address on the cover page. You're going to bring it down to your county clerk, my people, okay? You're going to have the original notarized. You're going to have 1 to 2 copies and a valid ID. You're going to ask for the miscellaneous recordation or recording a private document or the land records. You're going to pay the fee. Sometimes it's usually between $5 to $20 per page. It can vary. Now, you're going to have to get proof, okay? You're going to receive a file number or an instrument number. You're going to have a stamped copy for your records, okay? This is your public evidence that the trust exists. Now, that's a strategy, okay? Now, basically, it's going to show that the trust exists, you're the creditor in the position, etc., and it strengthens the record by filing it in that form. So it's your certificate of trust at the county clerk, but it's called a memorandum of trust. Now, if you're going to also have to include a UCC1 financing statement, because your first things first, you can do a UCC1 on your trust because it holds property and you have an interest. The trust has an interest in that property. So you file a UCC1 financing statement at your Secretary of State. It's going to create a commercial or a public notice. Okay? So while the county filing creates a land record of it, you're creating a public record by filing a UCC1 financing statement. Together, they form a strong, airtight paper trail. Now, if you don't have, a lot of money like that, and you want to understand some other stuff, we're going to get into that too. So, recording your trust proves that the trust exists on a public record. It shows you as the trustee. Okay? Now, it's simply evidence of a structure and authority, not a change of your legal status, but it's showing your evidence of a trust on the record. Now, basically, you have your Living Estate Express Trust, right? It will include your certificate of trust, recordable, your cover sheet for the county clerk, your UCC1 filing template, commercial notice, and your filing instructions so that you can execute it step by step. Your certificate of trust title is going to read a certain way. Give us a call. We can help you out with that. 407-300-5377. Now, we're going to go into about this, that cover sheet. There's a cover sheet and how how it's supposed to go and what it needs to say. We have that UCC1 financing statement. of what you need to put in that UCC finance in one statement. We have the steps, okay? Now, you're going to notarize your certificate of trust right in front of the notary, okay? You're going to take that down to the county clerk, right? You're going to pay a fee. It depends on your county clerk fee. You're going to get it stamped with an instrument number. You need the instrument number. Now, you're going to have a UCC1 financing statement that you're going to file, okay, to show proof of the secured party who has interest in the property. Now, we can help you with all of these steps. Now, the completion of this first strategy that we're giving you is a public record of your trust, proof that you are the trustee, commercial notice with the UCC. So, as we move on into the next strategy, my people, the strategy is going to get simpler because the first strategy that we told you costs a lot of fucking money. Straight up. We're going to get into the cheaper strategies on how you can get your trust on file. Okay? Now, we are going to go into the establishment of the structure and supporting your claims, okay? Now, you have affidavits of your authority and your status. You have a declaration of trust ownership of assets. You have your notice of fiduciary, your relationship, your IRS Form 56, your 2848, your 8821. Okay? Those three forms go into your trust package on your UCC1. You need help with that. 407-300-5377. That's what our expertise is, paperwork. Now, we can help you with all that trust packaging, okay? Now, we're going to get deeper into these other strategies. Now, basically, we all know that you can go to deeds.com and pull up any goddamn document, but it has to go with your trust. And if you're doing it like that, you're going to have a block and lot number. And that's where people fail down at the county clerk. Block and lot number. So, we know that deeds.com has these pre-made deed of templates, recording forms, and all of that, yada, yada. Great. We need that, okay? But actually, what is required for these next cheaper methods that will get your trust on file quickly. Now, if you want to record your trust with the county, we talked about that already. Basically, we're moving in to your trust, a deed, a warranty, or a quick claim. You can do that. A lot of you already know about a quick claim. You can transfer the tax forms. If you have property such as a mortgage, you're going to have to transfer your tax forms. So that can be done over the acreage system, easy. And you're not standing in front of a fucking clerk at the county who's going to tell you some bullshit. Now, for your situation, my people, based on what you're doing, we need to know what your situation is. So if you're establishing a public record of your trust and you're operating your trust as the trustee, and the trustee is the fiduciary on the Form 56 and 2848, okay? IRS tax forms. That is a paper trail. along with the UCC, because the UCC is the public recording for your entire trust. You have 4 ways that you can put a trust on file. The first way is a UCC-1 financing statement. The county clerk, probate court, and there's one other way. Now, basically, you're building your paper trail of a trust that is in existence. So, the county clerk only checks if it's notarized, if it is legal, and is the fee paid. That's what the county clerk looks for. That's what ACRIS looks for also. Now, the county clerk doesn't verify the trust structure. It doesn't verify your claims. It is not your legal theory. So, as you move on into these strategies, you have to understand that compliance for recording your trust is a format. You must follow the format of the certificate of trust to get on file. Now, each county clerk has its own set of rules. You must call to the county clerk down at the office before you go, if you want to go in person, to find out what the procedure is before you waste your time and don't look like an asshole in front of the county clerk. Now, to record your certificate of trust in a format, give us a call, 407-300-5377, and we can help you with the format. Now, we can help you step by step with the ACRIS system, all of that. Now, what you need to bring to the county court, my people, is the notarized certificate, 2 copies of it, the recording fee, and your ID. Okay? Now, ask the clerk, I would like to record a private document in the records, in the miscellaneous records. So, you would say to the clerk, I would like to record a private document in the miscellaneous records. Or you could say, I would like to record a private document into the land records. Or I would like to record my memorandum of trust onto the land record. Okay? They will stamp it with a recording number for the public record if they approve you. Okay? It's all about them approving it. Now, we're going to go on into these other strategies. So, after recording it, you'll have your public instrument number, your proof that your trust does exist, and the proof that you are trustee is what you need. So, your trusts are private by default, but once you put it on the land record, it becomes public. Once you put it on the UCC record, it becomes public that you are a secured party with interests of the property and you're liening it. So, they only record it if it is tied to real estate, a court case, or are voluntarily recorded in the county records. So if you have a court case, that is property. And there you go. Now, we're going into other options, my people. So, if you have a DBA of your trust name, you can file that online through that office where you have the DBA of the trust name. And we're going to finish this out. So stay in there. You could prepare the document, my people. You can use the certificate of trust created, okay, you can, same old thing, notarization, everything is notarized. You can go to the e-recording system in any state you're in, but you have to register yourself. Okay. So basically, if you're in Florida, it's called simp file or CSC e-recording or EPN. 3 places to record a trust in Florida. Now, basically, we are going to go into, if you're operating, you're operating your trust, your DBA, you're the creditor fiduciary position. So you have a structure, right? You have a 3-layer public record, right? You have a county recording, whatever state you're in. You have a county recording, whatever state you're in. You have a UCC filing on the state level of your trust, okay? Now, you're creating the land record, you're creating a business presence, you're creating a commercial notice. So the commercial notice, the UCC, the county recording is a land record and a business presence. So you can file online in any state, but you have to follow their rules and their regulations. Okay? Now, if you need help with the county recorders in other states, give us a call. 407-300-5377. Okay, and we can help you with that. Now, let's get into how we can file something and not have to spend any money. Okay? Now, this is the part that you really want to dive into, because if you don't have a whole bunch of money to spend on getting your trust on file, then you're tuning in right now at the right time. Because we're going to tell you how to get your trust on file without spending any money. It's just going to take your time that you're going to have to do. So, now we talked about the acre system already. We talked about the county clerk already. We talked about that UCC1. Okay. So we talked about the affidavits that you're going to need to put with your trust if you want to put those affidavits with it. So now we talked about that it proves your trust exists publicly. We talked about it shows that you are the trustee. We talked about the documented claims and the structure. We talked about the administrative and the business context, okay? Now, the affidavit of trust and authority is a sworn statement of trust existence, trustee powers, control over the assets. You have your fiduciary relationship. That's that IRS Form 56, 2848, 8821. You have the assignment of the assets to the trust. Internal documents showing assets belonging to the trust. To transfer those assets over, you have to create your bill of sale, and we're going to get into that also. So, we have a plan that you can use. You know what I'm saying? Depends on the states that you're in. But you have to have the credibility, the traceability, and the evidence. That's what our plan creates for the trust. So, you have an affidavit of authority, a court level style. You have, we talked about the real property is land, houses, and buildings. That's real property. A car is considered personal property. Okay? It's chattel, not real estate. You have to transfer your car into the trust, and you have to take it down to the DMV, and you have to transfer the title over to the trust down at the DMV. That's the only way to transfer your vehicle into the trust, and that it's on record. So that's what you have to do. And if you're driving it, they're going to ask you for the car insurance. So the car insurance, it's going to, you're making the vehicle, when you transfer it into your trust, it becomes commercial and it becomes a business. Now you have to pay higher car insurance on the vehicle for the transfer of the vehicle into the trust and out of your name. So, that's going to take you some time. That costs money. So basically, you're dealing with the title system, and vehicles are tracked through the New York State or Florida State or California State Department of Motor Vehicles. Wherever your motor vehicles is at in your state is where you're going to transfer your title into the trust to. So that's where the ownership is recorded. That's where the liens are listed down at the DMV for a vehicle, not a house. The title transfers happen down at the DMV for vehicles, trucks, all shit like that. So you have your UCC filing of the transfer of the public claim on the car as the interest that you have tied to your vehicle. So it's the VIN number, it's the vehicle description. This creates the commercial public notice, not the title ownership. The title ownership is down at the DMV, but the commercial public notice is on the UCC1 financing statement. Now, you're dealing with the ownership. So you can connect your car to your trust by assigning the vehicle to the trust or titling the car in the trust name through the DMV. So if you're assigning the vehicle to the trust, it's through the UCC. And then if you're titling the car to the trust, it's through the DMV. Now, through the DMV with your supporting documents. So now, if you have a situation, you're working with your trust, your UCC filings, your public record strategy, you have a structure that is correct. You have a DMV title ownership layer. You have a trust assignment internal control. And then you have a UCC public notice layer. Okay? So, in reality, my people, vehicles being vessels, registering cars, inland records, the actual practice, my people, courts and agencies do not treat cars as real property. The ACRIS system will simply reject your filing if you're trying to add a car as property. They won't accept it. They'll accept your court case as property through ACRIS. Okay? And we can tell you how to get those court cases, the court cases that matter with the certificate of ownership of your court case. Give us a call, 407-300-5377. Now, we're going to get deeper into this. You know what I'm saying? This might blow your wig off. Pull your locks out. Shit. Now, we talked about the Form 56. So it notifies your Internal Revenue Service that you are the acting fiduciary, trustee, executor, guardian, etc., conservator guardian, custodianship. You know what I'm saying? You are the responsible party for handling the tax matters for another party, like a trust or an estate. So, this establishes your communication authority with the IRS. It tells the IRS to send the notices to you as the fiduciary. Okay? So you have to complete that Form 56 package. You need help completing it? We got you. Now, your authority, you got to check your authority, the creation of fiduciary relationship, attach it to the certificate of trust. Attach the Form 56 to your certificate of trust. Attach the 2848 to the certificate of trust. Attach the 8821 to the certificate of trust, the memorandum of trust. Okay? You include your income tax and all tax periods. So, move on to how to not spend money to file a trust. Okay? You have places where to send these IRS forms to. Call us up. We can give you that. Now, let's see something here, my people. Let's see how you're going to file a trust for free and put a record. Okay? You also I told y'all about the affidavit of fiduciary authority. You have to have one. We got the addresses on where to send it, how to send it, and who to send it to. So, basically, my people, right here, what we got for you. You're going to have to file a notice in the newspaper, a legal notice of that your trust is up and running. You have to file a legal notice. It helps you to easier file. You need your legal notice of your trust, and you're the trustee. You need your bill of sale attached to your memorandum of trust of the personal property that has been transferred into the trust, and your other property, your house, your court case. Okay? So, your personal property is going to be your vehicle, your bank accounts, and, all your jewelry, your shoes, your clothes, shit like that. Now, okay, we are going to get into now real property. I just told you what personal property was. The real property is land, houses, buildings, condos, commercial property, and court cases. Those are immovable property. Personal property is cars, bank accounts, furniture, jewelry, business interests, DBAs, contracts, intellectual property like music, books, all of that, poetry. That is movable property because it moves. Now, a mortgage, my people, is a legal agreement where property is used as collateral to secure a loan. So the borrower is you, the lender is the bank, the property is the collateral, the mortgage is the lien against the property. Now, you buy a house, you own the house, the title is in your name. The bank files a mortgage lien against you and the house. The mortgage gets recorded in acres or down at the county in the land records. You have to rebut what the mortgage company put on file. Okay? You have to rebut all presumptions the mortgage company has put on file, the car companies have put on file, whatever jewelry you bought, assets you bought, you have to rebut it on your UCC. Now, real property must use a deed, okay, recorded in the acres or down at the county. Personal property uses an assignment document you created and a UCC filing. So, title is controlled by whatever motor vehicles is in your state. So, you have to take the title out of the motor vehicle DMV's name and put it into your trust name. Because whoever the lien, if it was finance, is recorded there down at the DMV. They put it in the DMV's name or in the name of the people who lent you the money. So, everything is a vessel. Everything is a vessel, my people. We show you how to find these court cases and get the ownership certificate of your court case. Everything can be treated as real property, okay? So actual legal and administrative systems, my people, are agencies strictly. They're separate. Real property is the land system. Personal property is a commercial system, UCC. So, property, anything that you own, split into real land or buildings. Personal is everything else. So, your mortgage, a lien on real property is a mortgage used to secure a loan. Okay? So, acre system or the county, only for real estate. The DMV is used for transferring the title of vehicles. The UCC is a commercial claim, interest, security interest. Now, the trust assignment, internal control. Okay, you can assign that on a UCC. Now, basically, we're going into how do we get to not spend money? Okay? We talked about the quitclaim deed and the warranty deed, okay? We know that whoever is the grantor, and then you have a grantee, a new owner, okay? So, John Doe hereby conveys to John Doe as trustee of the Living Estate Express Trust. Okay? So, you are required to have a deed if you're going through the acre system, RP 5215 document, TP 584, a transfer tax form document. Okay? No money is exchanged. You still file these forms, usually marked as exempt. Okay? They'll either approve it or they'll send you back something where you may have to pay. The grantor must sign it and it must be notarized. Now, the acre system, is outside of the county clerk. The acre system is online. The county clerk is physical down at the county where you walk in. You can record the deed. Trust becomes a legal owner of the record. So now the trust is the owner of all your property. Okay? You pay the recording fee, you transfer the tax, often exempt for trust transfers. So, you must be careful, my people. Mortgages have a due on sale clause. Okay? So, bank could call the loan due if the ownership transfers, which means you may have to pay the entire taxes or the entire mortgage. Depends on what your documents are going to say or what they're going to say down at the county clerk. So, under the federal law, my people, transfer to your revocable living trust, where you remain beneficiary. Usually do not trigger that clause that we just talked about. So, best to proceed is best for you, my people. Be careful. Now, once the deed is recorded, the trust owns the property. You control it as the trustee. The public record reflects the trust ownership, can manage, lease, sell through the trust. Okay? Now, the system becomes trust. They hold the title. The county or the acre system, public proof of ownership. The UCC is a commercial notice layer. The IRS is the Form 56, tax authority structure. Okay? The tax authority structure, my people. Now, what we want to do is have a checklist, my people. We want the deed created correctly. We want the trust name properly written. We want the forms RP 5217 plus the TP 584 done properly. We want it notarized, and we want to have our fees ready. Now, let's go in, right? You have your memorandum of trust. Now, you must get your memorandum of trust notarized and authenticated at the county, and if you can, at the state level. Now, a memorandum of trust, also called a certificate of trust, in many states is a short form public document that proves your trust exists without exposing the full trust agreement. So, full trust agreement, memorandum, or certificate is public. You record it, that's a memorandum of trust. Certificate of trust is public. Your full trust agreement is private. You keep it. Nobody knows about it. Now, like I said, the memorandum of trust, you want to get it notarized and authenticated at the county and the state level. You need a deed that transfers ownership. Memorandum of trust explains the trust. This is the cleanest way, that most and professional way to file it. Okay? Now, you can record it as the miscellaneous record. Okay? So it's similar to doing it with a certificate of trust. Okay? So basically, the purpose is to prove authority. Okay? It summarizes the trust for your public use. So you use your certificate of trust to walk into the bank, the IRS, recordable, yes. Interchangeable, yes. So the memorandum of trust is a stronger memorandum, usually includes your trust name, date of trust, trustee name, powers of trustee, statement of revocability, authority to hold real property, your signature, and a notarization. So when recorded with the deed transfers the house into the trust. The memorandum explains trust authority. This protects privacy, strengthens the record, and makes title companies comfortable. Okay? So, my people, it's going to provide proof of your trust, support real estate transactions, show trustee authority. So, we went through all of that strategy. Record certificate or memorandum of trust. Either works. But the cover sheet is called a memorandum of trust for the recordation of a certificate of trust. So you record all of that with a deed plus the memorandum together. And we talked about everything that goes into the deed. So we're going to talk about some stuff that a lot of people don't really talk about. Okay? So talked about all of that miscellaneous stuff. So if you're trying to record your memorandum of trust alone in the ACRE system, it's going to reject it because you need real property. Okay? So basically, the goal here, my people, is to anchor a trust into the ACRE system or down at the county without owning property. Let's tell you how we can do this. Okay? Without owning property. It's a workaround. You know what I'm saying? So, a nominal deed, most common attempt. Okay? A lot of people try it. They create a deed transferring a very small interest, like 1% or nominal interest, or reference vague property language. Then attach a memorandum of trust. So you can take 1% of a property that somebody deeded over to you just to get that trust on file. If you don't have a court case or something else like that. So if that's missing, it's going to get rejected. Okay? You have another workaround, air rights, intangible interest filing, where people describe airspace, equitable interest, energy, property. Okay? That's another workaround. You got another workaround. Is you can use property, friend or relative's property. If someone owns real property, it agrees to transfer interest to you, which we talked about earlier. They can create a real deed of transfer, partial interest, 1% of that, and attach it to the memorandum of trust. Okay? The trust becomes part of the property record in the ACRE system or down at the county. Now, a real legal transfer, not symbolic, okay? So it affects your ownership, your taxes, and your liability. So you better be careful. You got another workaround, my people, a mortgage security instrument trick, all right? A private mortgage. Name trust as secured party. You name the trust as the secured party of the mortgage. Okay? Without real property, real borrower or lender relationship, it can get rejected. We have another workaround. We have assignment of rents contract rights. So you can assign future rents, beneficial interests. So it may get rejected unless tied to actual property or recorded lease or a mortgage. So you better watch out with that. So basically, what really works, people, is a deed, real property transfer, mortgage secured by a real property, assignment tied to real property, related documents referencing a valid block and lot. So, the county clerk, you have to go into the miscellaneous records or the land records with a certificate of trust, memorandum of trust, UCC filing. But we have some other stuff. It also, what that is going to give you, the IRS gives you a public record, a commercial record, and a federal record. The federal record is the IRS. The commercial record is the UCC. The public record is the county clerk or the ACRE system. Okay? You can do all of that without needing ACRES. Okay? Now, ACRES is powerful because it ties to tax parcels and land ownership. Without land, there is nothing for ACRES to attach to. So that's why you get rejected in the ACRES system, unless you have a court case. Okay. So, my people, we getting down to some next level shit right now. Okay? Let's get into this next level on how to record this trust. Okay? On how to file this trust. So basically, your document format has to be a standard of 8.5 by 11 inches, single-sided, clearly titled Memorandum of Trust, indexing the information, the list of the grantor and trustee, list of any property, if you want it tied, miscellaneous record number signed by a clerk. Okay? So, you have your benefits are, you're going to have a public notice of the trust on file down at the county record or in the ACRES system. You're going to have a trustee of authority, the protector. You're going to have your reference in contracts, assignments, and UCC filings. You are going to be useful if no property is owned. It's okay. So let's go into, that block, that block fee is going to cost you some money, anywhere from $150 to $300. This is why we're taking you another way. If you can't get it done that way, then you can do a non-deed recording in the miscellaneous records if they allow it. And that's really hard to do. So if you don't have records, don't have a block or a lot, indexing requires you generally do not pay a deed block fee or a transfer tax for these. If you don't have it, you don't pay it. Okay. There is a really important piece of information that people need about the trust. You must publish it in a legal newspaper, a small fee, or you can post it online as a public notice platform in free public notice platforms online. You have to search for them, where you can put your certificate of trust up into their system that lets them know that you have a trust. And that platform is free, but you have to search for them. Now, it serves as a constructive public notice if you can get it on any free platform. Okay? So, you can notarize your trust certificate. You can keep a digital copy with you a timestamp, so you can go on any timestamp website and upload your trust certificate. So now it's time stamped, and then you download the timestamp of the certificate. Now you have it in their site on the blockchain as a digital timestamp of your trust for free. Okay, it creates proof of an existence without paying clerk fees. So if you don't want to pay the clerk fees, you will have to digitally timestamp your certificate of trust at one of the timestamp places online. And that's free to have your trust in existence without paying clerk fees. So the advantage of that is to legally verify the time-stamped trust and public record that you have made that has been time-stamped through the blockchain. So that is a free way to get your trust on file. Okay? You can record a certificate of trust or a memorandum of trust as a miscellaneous record at the DOS Division of Corporations. So you have to do your due diligence to do that. So once you have notarized and authenticated your certificate of trust at the state and at the county level, that can be uploaded on any free site for a notice and a timestamp. Now, your true public record in the county land system and the acre system of deed, the acre system and the deeds in the county land record system at the county, is not done for free. Right now, I'm giving you free ways of how to record your trust on the public record. Okay? UCC is not free. Okay? All free methods give public notice or state level record, but not official real estate recording. So if you want an official recording, you have to either go down to the county or you have to go through the acre system. So you it's up to you how you want to do it. We can only give you a direction to go in. So the public record that we can give you a package of got to call us up, 407-300-5377, and we can give you what you need. So you want to get that timestamp. You want to get a digital timestamp. You want to get a blockchain timestamp for free. Or it might be a minimal fee to get your certificate of trust on file as a public record for free. So the purpose is going to create an independent, verifiable record of a trust creation. Free time stamping services, okay? So you could go to notarize.com where they can notarize your documents for you if you don't want to go down to the county or leave your house. So you convert your notarized memorandum into a PDF, you submit it to timestamping services, you keep proof of the timestamp, okay? That's your receipt from the blockchain. You can do a self-published public notice. Sometimes they're free or they have a very low cost. We talked about that. So, my people, we have dropped you quite a free ways. We have the public notice. If you need that, 407-300-5377. So the bottom line, my people, is this is another public announcement from the United States, private enterprise free state, in on the check on. Stay up, stay one, stay strong. Contact 407 300 5377 to get this info. If you need some help with this process, give us a holla holla and we'll get at you. Peace to all my people in the chat. Robert Hollins, peace. You know what I'm saying? Shuk Raja, peace. And peace to all my people in the private chat. Peace to Linda Lee. Peace to Kitty Tushatashi. Stay up, y'all. Stay one. Stay strong. We have dropped you all the info on trying to get your trust up on the public record. This is another public announcement from the United States, private enterprise free state, and we are out.